In order to find out how weak or strong the case is, a lawyer will ask about liability, damages, and coverage. A contingency lawyer wants a case where liability is easy to prove. A contingency lawyer wants a case where there is a high dollar amount being owed to their client. And a contingency fee lawyer wants a case where the wrongdoer or their insurance company will pay justice. Knowing what is a high-value case and having a basic understanding of liability, damages, and coverage may find you the leverage you need to negotiate lower fees with a contingency lawyer. Let's talk about liability first. Liability is defined as the state of being lawfully responsible for something. Basically, if someone is liable, they are at fault. Before any contingency fee agreement is entered into, a lawyer considers how easy or difficult it will be to prove liability on the client's behalf. A lawyer's calculation is different when working a case on contingency as opposed to getting a cash retainer for legal fees. An attorney usually takes a case on contingency if they think the case has a decent chance of being proven. When it is easier to prove liability, the less work the lawyer may have to do, which may convince the attorney to accept a lower fee. The harder it is to prove liability, the less likely an attorney will consider a fee reduction. Let's look at an example of when liability may be easy to prove. For example, if you were the victim of a rear-end collision, in such a situation, the third party's insurance company may accept full liability from the start. If the offer for settlement from the insurance company is good enough, the lawyer may not even have to file a lawsuit. Some other cases, like medical malpractice, birth injuries, and dangerous drug claims, can be extremely complex and require a lawsuit from the start. There may be multiple defendants in the lawsuit who share liability for the victim's injuries and suffering. These complicated cases can be very expensive to litigate, with extremely high costs for medical and technical experts, as well as extensive discovery. Sometimes there are only a few highly specialized law firms which can handle such complicated cases with high costs. Factors that may create higher risk for the attorney may include the client having some fault or liability in what led to their damages, the client having similar previous injuries, the client's claim being denied by an insurance company or other party, or a lack of evidence in support of the claim. That is why it may also help to gather and organize a case file prior to a consultation with a lawyer. If you perform a lot of the work before hiring the attorney, you may have a valid reason for the lawyer to lower their fee percentage. Preparing a case file also helps by making it easier for the lawyer to estimate the value of the case, which is a perfect segue to the second point of leverage or element for a lawyer taking a case on contingency: damages. Damages basically means money. Money that can be recovered in the courts when one has suffered loss, detriment, or injury, whether to their person, property, or rights through the unlawful act or omission or negligence of another. Damages are meant to compensate for such things as injury, property damage, medical bills, lost income, and other damages that resulted from whatever issue is at the center of the case. A high amount of damages is a great point to make when asking a lawyer to consider reducing their fees. In any event, you can ask the lawyer to provide you with an estimate of the value of the case. It's important to know all you can about your case and its estimated settlement amount before you sign a contingency fee agreement. Unless your attorney offers to lower their rates, it may be up to you to ask. But let's say you had a case where there was a low amount recovered compared to the estimated damages. Some attorneys will agree to reduce their fees when the net amount payable to the client would otherwise be unreasonably low. Although reducing a contractually agreed fee is not required by law, some attorneys believe it's unfair for their clients to receive so little, especially after all the pain and suffering they've endured. So let's now talk about coverage. A lawyer working on contingency is interested in finding out if the other party has coverage. Coverage is basically the ability to pay money. A party can have coverage in a variety of ways. One is insurance coverage. For example, under California law, drivers are required to carry a minimum amount of insurance in order to drive. But sadly, there are people who can't afford to drive with insurance and get into accidents. Without other forms of coverage, such as money, assets, accounts receivable, or property belonging to the at-fault party, the victim may have a case where there is inadequate coverage for the legal damages or money they would be entitled to. Going after a defendant's personal assets is a different fight than going after an insurance company's. Many lawyers are not inclined to accept cases on contingency where insurance coverage is lacking. In sum, where there is inadequate coverage or only personal assets, one may have a tough time getting a lawyer to agree to a fee reduction. Repeat, read, and follow us to learn more valuable information on dealing with lawyers. Call or click Plied Legal for a free and confidential case evaluation. Even if you have an existing matter, one of the independent attorneys will provide you with a free second opinion. Up next, the sliding scale.